9-0 on a gun rights case in 2026. If you follow the Supreme Court even loosely, you know how rare that combination actually is, rarer than a coin flip landing the same way 10 times in a row on a bench this ideologically split. Second Amendment cases at this court almost always split along predictable lines, 6 justices one way, 3 the other, opinions running dozens of pages picking apart the same 18th century historical record from opposite conclusions. On June 18, 2026, that pattern broke completely. Every single justice, from the most conservative to the most liberal, agreed on the outcome of a case involving a marijuana user, a legally owned gun, and a federal law carrying a 15-year prison sentence. And if that surprised you, wait until you hear what happened 8 days later, when a second, far more divided ruling quietly rewrote the rules for millions of concealed carriers in 5 different states, splitting the same 9 justices almost exactly down the ideological middle on a completely different constitutional question. I am going to walk through both decisions in the order they actually matter, not the order the headlines picked, using the real opinions, not the summaries of summaries currently circulating, and connecting them in a way that most single-topic coverage never bothers to attempt. Quick housekeeping. I track Supreme Court rulings and the state-level scramble that follows them the moment they are handed down, not the recycled version that shows up in your feed weeks later, already half wrong, stripped of the nuance that actually determines whether a specific rule applies to your specific situation. If that is useful, subscribe and turn on the bell, because both of these rulings are about to trigger legislative responses in multiple states, and I intend to be first, not last, to break those down. 2 seconds, and let's get into the case that actually surprised legal analysts the most. Start with the facts, because they matter more than the legal theory here, and they are stranger than you would expect from a gun rights case. Ali Hemani is a dual citizen of the United States and Pakistan, born in Texas, who spent most of his life in the Dallas area living with his parents and working a stable job. In 2022, federal agents searched his family's home, not over anything related to guns or drugs, but because they were investigating suspected terrorism-related activity connected to the family. Based on the public record of this case, that suspicion never resulted in a terrorism charge against anyone. During the search, Hemani cooperated completely. He handed over a gun he kept in the house. He pointed agents toward marijuana on the property. He agreed to an interview and told investigators he used marijuana about every other day. More than 6 months after that search, with no terrorism case ever materializing, the government charged him under a completely different law, 18 U.S.C. Section 922 G3, a federal statute making it a felony for an unlawful user of a controlled substance to possess a firearm, carrying up to 15 years in prison and permanent lifetime loss of gun rights. It is worth understanding just how broad the underlying statute actually is, because that breadth is part of why this case reached the court at all. The law borrows its definition of controlled substance directly from the Federal Controlled Substances Act, a list that runs from heroin and methamphetamine down to far milder prescription medications, meaning the same unlawful user provision that reached Hemani over marijuana could, in theory, reach someone regularly using a prescription drug without a valid prescription, regardless of how mundane that specific substance is. The government's position in this case did not distinguish between those situations at all, treating any regular unlawful use of anything on that list as automatically disqualifying, which is part of what struck the entire court, not just the liberal wing, as too sweeping to sustain. A federal district judge threw the charge out. The Fifth Circuit Court of Appeals agreed with that dismissal, finding the government had failed to show that a regular marijuana user like Hemani is comparable to the kind of habitually intoxicated or dangerous individual that historical firearm restrictions actually targeted. The government, not satisfied, asked the Supreme Court to weigh in, and the justices agreed to hear it. Justice Neil Gorsuch wrote the opinion for a unanimous court, and here is the theory he rejected, stated as plainly as the government itself stated it in briefing. Regular marijuana use, on its own, with no other evidence, is automatically enough to strip someone of their Second Amendment rights permanently, regardless of how much they use, what effect it has on them, or whether they present any actual danger to themselves or anyone else. Gorsuch tested that theory by extending it logically. Under the government's own reasoning, he noted, The same automatic disqualification would apply just as easily to a husband who regularly takes his wife's prescription sleep medication or a college student who routinely borrows a friend's prescribed stimulant to get through exam week. Neither of those people would typically be described as dangerous, and the government's own theory offered no principled way to distinguish them from Hemani. The court held that prosecuting someone this way, on an admission of use alone with nothing more, is inconsistent with the Second Amendment. Here is the part that makes this case even more pointed. During the litigation itself, the federal government moved marijuana from Schedule 1, the most restrictive category of controlled substances, down to Schedule 3, a formal acknowledgement of lower potential for abuse and dependence. Gorsuch used that timing directly against the government's own argument. It is difficult, he suggested, for the government to simultaneously argue that regular marijuana use makes someone categorically too dangerous to own a firearm, while also, in the same year, officially downgrading how dangerous it considers the substance to be. Add to that the fact that marijuana is now legal in some form in roughly 40 states, and federal prosecutors have been instructed since 2013 to generally deprioritize enforcement against marijuana users operating within state law, and the government's position looked to a unanimous court increasingly disconnected from its own actual policy. Now, the insider detail almost nobody explaining this case bothers to mention. This ruling is narrower than the 9-0 vote makes it sound. Gorsuch was explicit and deliberate about the limits. The decision does not address whether the government can disarm someone who is an addict as opposed to a regular but non-dependent user. It does not address someone who is presently intoxicated while carrying a firearm. It does not address more dangerous controlled substances. And it does not touch the completely separate federal law banning firearm possession by convicted felons, which remains fully intact and untouched. This provision, the unlawful user ban specifically, accounts for only a small slice of federal gun prosecutions overall. Roughly 5% of cases brought under the broader statute covering all prohibited categories of people, according to figures cited in the litigation. So, while the vote was unanimous, the actual legal territory it covers is deliberately narrow, and Justice Ketanji Brown Jackson, joined by Justice Sonia Sotomayor, used a separate writing to say so explicitly, agreeing with the outcome while arguing that the broader historical tradition test the court has used since 2022 produces inconsistent results across different courts and deserves reconsideration on its own terms. That critique did not change this case's outcome, but it is a marker from two justices that they are looking for the right vehicle to revisit the whole framework. 8 days later, on June 25th, the court handed down a second ruling that could not have looked more different in terms of internal agreement, even though it traces back to the exact same 2022 case, New York State Rifle and Pistol Association versus Bruin. That set the historical tradition test in motion in the first place. Bruin established that the Second and 14th Amendments protect carrying a handgun outside the home, and that modern gun regulations have to be justified by an actual historical analog, not just a policy the government thinks sounds reasonable. That standard replaced a softer, more forgiving test many lower courts had leaned on for over a decade, one where a law could survive as long as the government offered a plausible public safety rationale for it. Bruin removed that option. A rationale alone is no longer sufficient. The government must now point to an actual regulation from the founding era, or shortly after that is relevantly similar to whatever modern law is being defended, a considerably harder bar to clear. One more piece of the framework matters here, because both of this June's rulings lean on it directly. In 2024, in a case called United States versus Rahimi, the court clarified that the government does not need to find a historical twin, an old law that matches the modern one in exact detail. It only needs a historical regulation that shares the same underlying principle. That clarification matters because it is exactly what both Gorsuch in Hemani and Alito in Wolford spent much of their opinions testing, whether the specific historical examples each government lawyer offered actually shared the same underlying principle as the modern law being defended, or whether the resemblance was too thin to count. In Hemani, the government's examples did not hold up under that test. In Wolford, Hawaii's own attempt to root the vampire rule in obscure 19th century property statutes, including one tied to Louisiana's Black Code and another isolated 1893 Oregon poaching law, fared no better, with the majority opinion dismissing both as too narrow, too regionally isolated or too disconnected from actual firearm regulation to establish the kind of broad historical tradition Hawaii needed. In the aftermath, several states that could no longer simply deny carry permits at their own discretion pivoted to a different lever entirely, restricting not who could get a permit, but where that permit actually functioned once someone had it. Hawaii's version of that pivot, a 2023 law called Act 52, flipped the default rule that had always governed private property open to the public. Under ordinary common law, anyone has an implied license to walk into a business that welcomes the public unless the owner says otherwise. Act 52 reversed that presumption specifically for licensed carriers, treating every business as off-limits by default, unless the owner affirmatively said carry was welcome, through a sign, spoken permission, or something in writing. Critics inside the litigation nicknamed it the vampire rule, because, like the old folklore, a lawful carrier's right could not cross a business threshold unless specifically invited in first. Jason Wolford, a Hawaii concealed carry permit holder, along with other Maui residents backed by the Hawaii Firearms Coalition, sued, arguing the list of default off-limits locations was so broad it functionally erased their permits during an ordinary day of errands, gas stations, grocery stores, dry cleaners, the exact places any resident actually goes. The case had a genuinely interesting run through the lower courts. A Ninth Circuit panel reviewed Hawaii's law alongside a similar California law in September 2024 and split the two, striking down California's stricter sign-only version while upholding Hawaii's more flexible sign or verbal or written version. An en banc rehearing request was denied in January 2025, and the Supreme Court granted certiorari that October, limiting review specifically to how the Second Amendment applies to privately owned property open to the public. Oral argument came on January 20, 2026, and the ruling landed 5 months later. Oral argument on January 20th gave a preview of where this was headed. Chief Justice Roberts pressed Hawaii's attorney, Neil Katyal, specifically on the vampire rule nickname itself, asking him to confirm that part of the historical tradition Hawaii was leaning on really did amount to the old common law idea that a person needs an owner's consent before entering. And Katyal agreed with the framing, which several observers took as a sign the argument was not landing the way the state needed it to. Legal commentators covering the argument came away describing the conservative majority as clearly skeptical of Hawaii's position well before the written opinion confirmed it 5 months later. By a 6-3 vote, the court held Hawaii's default rule unconstitutional. Justice Samuel Alito wrote for the majority, joined by Chief Justice Roberts and Justices Thomas, Gorsuch, Kavanaugh, and Barrett, with Barrett filing an additional concurrence partially joined by Thomas and Gorsuch. Alito's opinion walked through exactly how a single ordinary day, a stop for gas, a trip to the grocery store, a drop-off at the dry cleaner, could turn a licensed, law-abiding carrier into a repeat criminal without them ever intending to break any law at all, and concluded that inverting a right into something contingent on a stranger's permission is not how the right to carry has historically functioned. Justice Jackson, joined again by Justice Sotomayor, dissented, arguing this was never fundamentally a gun rights case, but a property rights one, that requiring permission before entering someone else's business with a weapon does no more violence to the Second Amendment than requiring permission to enter their home would. Justice Elena Kagan filed her own separate dissent as well. 3 justices, in other words, saw the exact same facts through a completely different constitutional lens than the 6 in the majority, and that disagreement did not get resolved. It simply lost 6-3 for now. Do not mistake this for a ruling that erased every restriction everywhere, because it specifically did not. 3 things remain fully intact: sensitive places, schools, government buildings, courthouses, polling places were not before the court in this case, and remain fully restrictable under both federal and state law. Actual private homes are completely untouched. Nobody gained any new right to bring a gun into someone's residence without permission. And individual business owners retain full authority to ban firearms on their own property. They can post a sign, they can say so verbally, and a customer who ignores that after being told is still trespassing. Full stop. What flipped is only the default. Silence used to mean carry was presumed banned. Now, silence means carry is presumed allowed unless the owner actually says otherwise, which is a meaningfully different legal starting point, but not the elimination of an owner's control over their own property. This ruling's reach extends well past Hawaii. Court reporting on the case identifies 4 other states: California, Maryland, New York, and New Jersey, with similar default rule laws enacted after Bruin, and the 2nd, 3rd, 4th, and 9th circuits had already been chipping away at versions of this scheme, state by state, before Wolford came down, with Maryland's case sitting at the Supreme Court's door waiting specifically on this ruling. Wolford technically resolves Hawaii's statute, not the other 4 states' laws directly, but it sets the controlling standard those other courts are now bound to apply, which is why legal observers are already describing the default rule strategy as functionally dead nationwide, even though each remaining state's law still has to be formally struck down through its own case. Watch how each side actually responded, because it tells you more than the vote count does. Gun rights organizations celebrated this as one of the cleanest, most decisive post-Bruin wins to date. Groups on the other side, Every Town for Gun Safety and its affiliated Moms Demand, Action and Students Demand Action networks, did not claim the ruling was reversible or contest its scope. Instead, they pivoted immediately toward encouraging individual businesses to voluntarily post their own no firearms signage, which is precisely the tool the ruling left completely intact. That response is itself the clearest confirmation of how narrow the practical shift actually is. Nobody serious on either side believes business owners lost their authority. The fight simply relocated from state statute books to individual storefronts, one sign at a time. Here is where this actually gets useful instead of just interesting, because knowing the case names does not help you if you do not know what to do differently starting today. If you carry in Hawaii, California, Maryland, New York, or New Jersey, the presumption you operate under has flipped, but you still need to watch for posted signage, because an owner's explicit no is still a no. They just have to be the one to post it now, instead of you needing to locate a welcoming one. If you are a business owner in any of those states who wants to keep firearms off your property, the tool available to you is exactly the same as it always was: a sign, a verbal notice, or something in writing. You simply need to actually use it now, rather than relying on the state law to do that work for you by default. If you are a regular marijuana user who also owns a firearm, Hemani protects you specifically from a prosecution built on an admission of use alone. It does not protect you if there is any additional evidence of impairment while armed, addiction, or a more dangerous substance in the mix, so treat this as a narrow shield, not a blanket one. And if you are simply trying to keep up with all of this as a citizen rather than someone directly affected, the honest answer is that both of these areas of law are still moving. Hawaii's legislature and 4 other state legislatures have not yet finished responding, and prosecutors are still working out exactly how far Hemani's floor extends in practice. Let me also clear up 3 specific claims already circulating since these rulings landed, because each one takes something real and stretches it past what the court actually said. The first claim making the rounds is that Wolford means concealed carriers can now walk into literally any building without restriction. That is false. Sensitive places like schools, courthouses, and government buildings were never part of this case, and remain exactly as restricted as they were before June 25th. The second claim is that Hemani effectively legalized gun ownership for any drug user, full stop, no exceptions. Also false, and Gorsuch went out of his way in the opinion itself to head this exact misreading off, explicitly preserving prosecutions involving addiction, present intoxication, or more dangerous substances. The third claim, more a timing confusion than a falsehood, is that California, Maryland, New York, and New Jersey's similar laws are already struck down and unenforceable this week. Not yet, technically, even though the legal writing is now on the wall for all 4, each state's specific law still needs its own case to run through its own circuit before it is formally gone, a process that is likely measured in months, not days. Let me connect a few dots here that most coverage keeps in separate boxes. Both of these rulings descend from the same 2022 Bruin decision and the same historical tradition test, applied by the same 9 justices, within 8 days of each other, and yet they landed on opposite ends of the agreement spectrum. Hemani found a floor every justice could stand on, that a right cannot be stripped based on an admission alone without individualized evidence of danger. Wolford found no such floor, splitting sharply over whether a property owner's traditional right to exclude outweighs a carrier's right to a default presumption of access. That contrast is the actual insider story here, not which side won which case, but what it reveals about where this court's supposedly consistent historical method actually produces consensus and where it does not. A framework that yields 9-0 on one gun case and 6-3 on another, using the same interpretive method both times, is not as mechanically predictable as either side likes to claim when they are winning. It suggests the historical tradition test behaves less like a formula that spits out the same kind of answer every time, and more like a shared vocabulary that different justices are still using to reach genuinely different conclusions, depending on how directly the modern law in question maps onto a specific historical practice versus how much interpretive distance a court has to travel to get there. That distinction, how much distance the government has to cover to connect its modern law to an old one, may end up mattering more to how future gun cases get decided than which specific justices happen to be sitting on the bench when they arrive. Here is what happens next, because neither case is actually finished. Wolford was reversed and sent back down, meaning Hawaii's courts and legislature now have to implement the new standard rather than the Supreme Court rewriting the statute itself, and expect Hawaii to attempt some narrower replacement focused on signage requirements or specific commercial categories, tested immediately against the exact reasoning Alito just laid out. The same calculation is now playing out quietly in Sacramento, Annapolis, Albany, and Trenton, where lawmakers backing California, Maryland, New York, and New Jersey's versions of this law are almost certainly reviewing their own statutes against Wolford's reasoning right now, trying to determine whether any part of their approach survives or whether a full rewrite is coming. Hemani was deliberately built narrow, which means expect federal prosecutors to pivot toward building future cases around individualized evidence of impairment or danger rather than an admission of use alone, and expect continued litigation over exactly where addiction, present intoxication, and more dangerous substances actually sit, since the court left every one of those questions open on purpose. Watch for the next case testing those exact boundaries, because Gorsuch's opinion all but invited it, and appellate courts already handling similar fact patterns are the most likely place it surfaces first. If this actually clarified what changed instead of leaving you with a headline and a guess, hit like so it reaches people who are currently getting a half-right version of one or both of these rulings, and subscribe if you have not, because the state-level response to both decisions is unfolding in real time right now, not on some future date, right now this month. 4 state legislatures are watching Hawaii's next move before deciding their own. Federal prosecutors are quietly recalibrating how they build cases under a statute the court just narrowed. And none of that shows up in a single headline the day a ruling drops. It shows up over the following weeks and months, which is exactly the part most coverage stops paying attention to once the initial story cycles out. Tell me in the comments which surprised you more: a unanimous court on a marijuana and guns case, or a sharply divided court on the private property question, because that tells me which thread to pull first in the next one, and whether you would rather see the Hawaii legislative response covered first or the prosecutorial shift under Hemani. Both threads are moving right now, and both are worth watching closely over the next few months, not just the week the ruling dropped.